Good day everyone, welcome again to another episode of Tax Training, and today I will discuss to you what to do when you receive tax assessment, no? Halimbawa, na-issue kayo ng letter authority, tapos nakapagbigay na kayo ng mga documents, and then mayroon ng result ng investigation yung inyong examiner, no? So pinapadala na kayo ngayon ng assessment kung ano yung resulta ng investigation. So, ito po yung gagawin natin, no? But before that, I would like to say thank you sa mga YouTubers natin, sa mga subscribers natin, and for those po na hindi pa nag-subscribe, please subscribe to our channel, and we promise to bring you more tax information. The purpose of our channel is for you to have a better tax compliance, no? So, what to do when you receive assessment, no? Assessment, ito na yung tax liability mo na nasa letter po ng examiners, no? So, under Revenue Memorandum Order number 26-2016 dated June 13, 2016, dito po nakasaad kung ano yung mga dapat gawin, no? So, ito yung mga guidelines na set po ng BIR, no? Ano po ang objectives ng guidelines na to, no? So, in line with Section 228 of the National Internal Revenue Code as amended and pursuant to Revenue Regulations number 18-2013. Ito po yung nag-amend ng 12-99, na yung 12-99, yun po yung original po natin na guidelines kung paano ang gagawin natin. Yun yung due process po pag na-tax audit tayo, no? Amend certain sections of Revenue Regulations 12-99 relative to the due process requirement in the issuance of a deficiency tax assessment. This order is hereby issued to prescribe policies, uniform guidelines and procedures in handling disputed assessments and in issuing final decision on disputed assessment or FDDE and revision thereof by the Commissioner of Internal Revenue. Policies and guidelines. A taxpayer must be given opportunity if he, she, or it so chooses to explain his or her or its objection to an assessment and present necessary document in support of his or her objection before an FDDE is issued. So, may due process requirements po tayo dito na bigyan muna ng opportunity ang taxpayer to explain, no, kung hindi siya papayag doon sa assessment, no? So, protest against preliminary assessment notice or PAN is optional, not mandatory. So, hindi mandatory. Why? Kasi kung wala ka naman dapat i-protest, so, hindi ka magpo-protest, no? Formal letter of demand and final assessment notice, FLD or FAN, shall be issued 15 days from date of receipt by the taxpayer of the PAN, whether the same was protested or not, no? 15 days, no? Yun yung time na ibibigay sa atin na bibigyan na tayo ng formal letter of demand, no? Pagka 15 days na na-receive natin and then hindi tayo sumagot, then i-final na yung assessment sa atin, no? So, if the taxpayer shall upon receipts of the PAN accepts and pays the assessment, either partially or fully, an FLD, no? Final letter of demand or final assessment notice, shall be issued to formalize the assessment, and payment form O605 shall be duly prepared. Kung acceptable yung assessment, then bayaran mo na using BIR form O605. No? Acknowledge and provide evidence for the settlement of the assessment or portion of the assessment paid. Yun yung BIR form O605. So within 30 days from receipt of the final letter of demand or the final assessment notice, the taxpayer shall either accept the assessment fully or partially and pay the amount due on the assessment accepted. Kung inaccept niya, then bayaran niya. Pagka hindi naman, protest the assessment fully or partially by filing either of the following remedy, and the filing of one precludes the filing of the other remedy. So, kung nag-protest naman siya at hindi siya papayag dun sa assessment, then pwede siyang mag-request for reconsideration or request for reinvestigation. So, kung mag-request siya na reconsideration, hindi siya pwedeng mag-request ng reinvestigation. So, isa lang. Request for reconsideration if the taxpayer is not going to submit any other additional evidence or documents and merely pleas for re-evaluation of an assessment, no? Pinapa-re-evaluate lang niya, kaya reconsideration lang, walang dokumento na ibibigay. Or pwede rin siya mag-request for investigation on the basis of newly discovered evidence or if the taxpayer intends to present or submit additional evidence or documents. No? Sa re-investigation, may dokumento kayo na isasubmit. Sa reconsideration, wala lang, re-evaluation lang. After the issuance of the final assessment notice or final letter of demand, the taxpayer accepts and pays the assessment in full. No? So, payment form 0605 shall be duly prepared, filed, and paid as evidence of the settlement of the assessment. So, kung acceptable na, then bayaran na sa form 0605. If the taxpayer accepts and settles or pays the assessment in part and protests the remaining portion, then payment form 0605 shall be prepared, filed, and paid for that portion of the assessment accepted and settled, and an FDDA shall be issued for the portion of the assessment resolved in favor of the taxpayer. An authority to cancel assessment or ATCA shall be prepared to evidence the cancellation of the assessment. Kasi po, pagka may assessment na, hindi yan nawala, na bayaran mo lang. Kailangan meron kang ATCA or authority to cancel the assessment, and then yung reason mo is payment, nagbayad na, kaya cancel mo na. No? If a request for investigation was made, the taxpayer shall submit all the relevant supporting documents. Kasi re-investigation, so may dokumento na ipepresent. In support of his or her its protest within 60 days. So 60 days ang bibigay sa taxpayer para makapag-present ng mga documents. From the date of the filing of the taxpayer's letter of protest. Evaluation of the protest shall be based exclusively on the documents submitted within the period, and no further document shall be accepted after the expiration of the said period. No? So the assessment shall become final and executory in the event the taxpayer fails to submit the relevant supporting documents within this 60 days period, and a collection letter and other collection remedies such as but not limited to garnishment, warrant, and levy shall be issued against the taxpayer. All decisions on protest to the fund, whether the taxpayer's protest is accepted or denied, partially or wholly, shall be communicated to the taxpayer through the issuance of a final decision on the disputed assessment or FDDA. No? So all protests shall be considered a request for reconsideration unless said protest clearly indicates that the request is for investigation. So, kung wala siyang sinasabi kung request ba siya ng reconsideration or investigation, the default is reconsideration. So, hindi magbibigay ng bagong documents. A request for investigation shall be available in a protest to final assessment notice, final letter of demand only. After the issuance of a final decision on disputed assessment or FDDA, a request for investigation shall no longer be available as a taxpayer remedy. So ito po yung sinasabi dito sa regulations na to. Pagka may FDDA na, hindi na po pwede mag-request ang taxpayer for reinvestigation or reconsideration. If the protest is not acted upon by the commissioner, so pinabayaan ng commissioner, hindi niya sinagot yung protest ng taxpayer, or the duly authorized representative within 180 days counted from the date of the filing of the protest in the case of a request for reconsideration, or from the lapse of the 60 days period to submit relevant documents in the case of request for reinvestigation, and the taxpayer appeals to the Court of Tax Appeal within 30 days after the expiration of the 180 days period, an FDDA shall be issued automatically. So automatic na yung final decision or disputed assessment, issue na po yan automatically. All the period provided for under RR 18-2013 is mandatory and non-extendable. So yung 15 days, 30 days, 60 days na mga binibigay na time for the taxpayer to comply, kailangan sinusunod po yun. After the issuance of the final decision on disputed assessment, the taxpayer may accept and settle the assessment contained therein, partially or fully. No? Payment form 0605 shall be prepared, filed, and paid for the assessment accepted and settled by the taxpayer. If the FDDE were issued by the Commissioner's duly authorized representative, then the taxpayer shall within 30 days from receipt of the FDDE file a motion for reconsideration with the Commissioner of Internal Revenue or appeal to the Court of Tax Appeal. No? So within 30 days, pwede naman mag-appeal yung taxpayer. In appealing the protest to the Court of Tax Appeal, the taxpayer shall manifest and state that the appeal pertains only to the portion of the FDDE not settled and paid an attachment to their appeal, a copy of the duly filed and paid payment form 0605. Appeal to the Commissioner or to the Court of Tax Appeal of the FDDE shall not preclude the taxpayer from voluntarily settling the assessment, partially or fully. Payment form 0605 shall be duly prepared, filed, and paid, and the taxpayer shall manifest before the Court of Tax Appeal the fact of settlement of the assessment, partially or fully, present the duly filed and paid payment form 0605, and file a motion for dismissal with prejudice as to the assessment or portions thereof that has been settled and paid on the ground that the appealed disputed assessment has become moot and academic. No? So an assessment shall become final, executory, and demandable due to, among others, the following grounds. No? Letter A, failure of the taxpayer to file a valid protest within 30 days from the receipt of the formal letter of demand and final assessment notice, no? FLD or FAN. And then letter B, failure of the taxpayer to submit all relevant documents in support of his protest by way of request for investigation within 60 days from the date of filing thereof. And letter C, failure of the taxpayer to appeal to the Commissioner of Internal Revenue or the Court of Tax Appeals, CTA within 30 days from date of receipt of the FDDE issued by the Commissioner's duly authorized representative. Failure of the taxpayer to appeal to the Court of Tax Appeal within 30 days from date of receipt of the FDDE issued by the Commissioner, or failure of the taxpayer to timely file a motion for reconsideration or new trial before the CTA Division, or failure to appeal to the CTA in bank and Supreme Court based on existing rules of procedure, or failure of the taxpayer to receive any assessment notices, magiging final na kaagad yung FDDE because it was served in the address indicated in the BAR's registration database. Kaya hindi niya na-receive kasi hindi siya nag-update sa registration database. And the taxpayer transferred to a new address or closed or ceased operations without updating and transferring its BIR registration or canceling its BIR's registration, as the case may be, through the accomplishment and filing of BIR form number 1905. Meron po tayong video for this. Application for registration information update as prescribed by pertinent issuance and or amendment thereto. So yung registration requirements po natin is very important that magiging daan siya na maging final yung final disputed decision or disputed assessment pagka hindi mo natanggap yung notice mo kasi wala ka na doon sa address mo, no? So final na kaagad yung FDDE. Okay? So ano po yung gagawin natin pagka nakatanggap na rin ng final assessment or ng notice of assessment, no? So we observe the number of days given to us to protest and then to submit any additional documents if we protest and we request for re-investigation. Pag re-evaluation naman, re-evaluation lang yun, wala nang dokumento na ibibigay, no? So please be very attentive on the number of days required, no? Para hindi maging final sa atin at maging liable na tayo doon sa assessment na ginawa sa atin ng examiners. So with this, I would like to say thank you. And for those na hindi pa po nag-subscribe, please subscribe to our channel and we promise to bring you more updates in taxation. Thank you and good day.